Hello, everyone, and welcome to this fourth and final part of the Intellectual Property Rights for Designers webinar series. First, I want to mention that this webinar is recorded, so if you do not wish to be heard or seen in the recording, keep your microphone and camera off. You can still send questions to us in the webinar chat, and at the end of the webinar, we will have time for questions, and you can choose if you want to ask them putting your microphone and camera on or in the meeting chat. My name is Rosa Joensuu. I work as a lawyer for Ornamo Art and Design Finland, where I advise designers on their business related legal questions, for example, contracts, intellectual property rights, and employment matters. Ornamo is Finnish Association for Professional Designers with a bit over 3,000 members who work in all fields of design. And this webinar series is part of the Design as a Competitive Edge project provided by Ornamo and BEDA, the Bureau of European Design Associations, and supported by the European Union Intellectual Property Office. And the aim of the project is to empower designers to know their intellectual property rights and how to use them in their business. And now I'm very happy to give the floor to Dita Danosa from BEDA to say a few words about BEDA and their part in this project.
Hello, everyone. I'm very happy and pleased to see you for this series of webinars to raise awareness of intellectual property rights across designers. I hope I'm able to share a presentation, a bit intro in the subject with invitation to the upcoming event what BEDA Office of European Design Associations will be organizing soon. So we are Office of European Design Associations uniting together 50 member organizations across all over the Europe, and in a context with the IP rights, really do bridging between designers and legislative authorities to help both to familiarize typicalities or typical challenges of designers and help designers to become more knowledgeable and really use the benefits of what IP rights protection is giving to you. So what we have done through this year, the most exciting event was in Riga. We organized a workshop within that day's project Rosa already mentioned. And why I'm saying it, because we really collected very useful feedbacks through the table discussions. I hope you will see familiar faces in the visual in the Zoom screen. So really all over the year we collected design associations feedbacks on the most main challenges regarding IP rights within designers. So through these fruitful and involving discussions, we found out that these main challenges we all face together, first of all are knowledge gaps. And that's why even these webinars are organized, and the knowledge gaps are in different fields. First of all, general knowledge about what really IP, intellectual property rights include, and how even they are beneficial for designers, the whole process too, and actually the angle from the business perspective too, how that protection helps to do better businesses. And next one, one of the most challenging aspects is protection gaps, both those because they are we know, and that's why I see Gailė here. We expect the upcoming legislation changes to be enforced because we see that historically everything was about the tangible design, physical design, not intangible elements of the design. So we see that upcoming legislation changes will solve partially problems, but we look for more. And then need for support was identified as one of the most challenging issues too. We see that there are the good funding schemes as SME fund, etc. There are cases that the designers are not aware of that, and we see that there's need for more and more such type of tools, even to foster help for designers, because we familiarize with the situation that as designers they don't know what they need to know. They are shy to look for the advice for local patent offices, EUIPO, lawyers, etc. So we should overcome that barrier, and we should look for the tools to work on power imbalances between designers and corporations regarding the transfer of design rights. So we came up just briefly about how to solve it. What are these? We tackled these most pressing issues. There are different solutions coming out, and we will look forward working on that on both with designers, other organizations, and EUIPO to find out solutions how to really implement them in real life. So now, promotional part, as this webinar will finish the cycle of the webinars organized from Ornamo side, we invite you to continue deepening your understanding on IP subject. And we invite you to our organized Wild Open Doors dialogue, which will happen on 26th of November at 3. So what we will be there, actually you can even scan QR code to register. There will be designers, internationally recognized designers will share their experience of design processes and will guide you through their own experience, what they protected, how it was, and what they gained through these protections. And of course, we will tackle these upcoming changes of this legislation, and we will have informal conversations what and how we can enhance designers' involvement in IP rights and protecting more and more designs, benefiting through that protection. So briefly from my side, it's that's what I wanted to say. There are my contacts. If it's something needed, please don't be shy. Contact with me or other BEDA representatives.
Thank you very much, Dita, for your presentation and for inviting everyone to the event. Now I will share my screen again. And I hope everyone now. And now I'm very happy to present to you our guest speakers of today. We have Gailė Sakalaitė from the EUIPO and Paula de Andrés Gómez from Berggren. And Gailė and Paula, would you like to say a few words about yourself, starting with Gailė?
Thank you, Rosa. Sure. Good afternoon, ladies and gentlemen. My name is Gailė. I work for EUIPO as a lawyer. Well, I have experience as a private practitioner. Also, after joining EUIPO, I worked as a trademarks and designs examiner. And now I'm working for the Legal Affairs Department at EUIPO, and I am mainly focusing on design legislative reform. So I lead the team of experts who work on providing support to the European Commission, drafting our contributions to the new law, and also we take care of implementation activities so that whatever is introduced into new law becomes operational. So this is more or less my tasks, and I've been participating in this legislative reform process since the very beginning, and hope that I can give you some insights into the process and changes, and I hope this will be useful. Thanks.
Okay, so I guess it's my turn.
Yes.
Hello, everyone. My name is Paula de Andrés Gómez. It's my pleasure to be here today with all of you. I'm a European design attorney and a partner at Berggren, where I have been working actually for almost 23 years. And the last 15 years, I have been focused on design protection, and especially on the how, when, where, and how, like the main questions on design protection. So what I do is I help designers to make the kind of like the strongest design protection possible. This is very important because without a good design protection, then you will not have a strong protection for your design. So all of these questions is what I usually work on my everyday basis. I work with designers with small companies, also with bigger companies, but we always look case by case. It's designed differently because each case is completely different. What type of protection it needs. I'm also very active internationally. I belong to several organizations, and I try to spread the word about design protection worldwide. Next year, I will have a good opportunity for that at INTA, which is one of the biggest conferences that there is about IP rights. So I will give some talks about design protection there. So yeah, any questions that you may have on design protection, I'm happy to help.
Thank you both very much for your introductions, and thank you for joining us for the webinar today. We are really honored to have you here with us. And before Gailė and Paula start with their presentations, I will still say a few words about designers' intellectual property rights. And maybe some of you have watched the previous webinars, so some of the things will be already familiar to you. But if not, you can scan the QR code and find a video where Ornamo's lawyer Iris speaks about designers' IP rights and gives an introduction to the topic. You can maybe save the link for later using this QR code. And all the links, I will show other QR codes as well. I will put in the webinar chat. So if the QR code is not working, no worries. And after the webinar, you will receive an email and the recording of the webinar, and we will also put these links there. Quickly to show you what intellectual property rights are. This is very simplified example, and I have put design here with green because I want to highlight that that's the intellectual property right we are addressing mostly today. Design protects the appearance or part of the appearance of a product. Here we see a picture of a lamp. So for example, it can protect how the lamp or part of it looks, or the packaging of the lamp. And you will later see more examples of what can be protected by design right. But just to show that this is the focus today. Other intellectual property rights, trademarks, and it's not a synonym to brand, but to simplify, trademark is the sign that helps you distinguish the commercial origin of the goods or services. Maybe once you bought a lamp that you really liked, and years later you want to buy another lamp, and you go to the store and you think, oh, the lamp I had was very good. I want to find from the same brand. And then trademark is the one that helps you to distinguish the many lamps of many companies from each other. Then patent protects the technical solution, how the lamp works, and it gives protection to that. And then copyright, expression of ideas. Design, trademark, and patent need to be registered, and copyright protection you get automatically when you create topic. You should with the lamp, you could protect the design, or part of it looks. You can at the same time have a brand registered. You can maybe protect how the lamp, the technical solution in the lamp with, and if it's original, it may get copyright protection as well. You get the strongest protection by using different forms of protection together. Then about the design right, what was marked with green earlier, these are the things you should sign. First question, where should I register? These are territorial rights. So you have protection in the area where you register it. If you register in one country, you will have protection there. Or you can, for example, register at the EU level through the EUIPO, and then you will have the design right at the same time in all EU countries. This is something you should think about, where you need the protection and where you want to register. Then the requirements for registration are novelty and individual character. So when you create the design, ask this question: should I publish my design yet, or do I want to register the design right? Because the design to be registrable needs to be new. There is an exception to that, which is this grace period. So if you want to test the product on the market, you can publish it and within 12 months apply for the design registration. But there are some risks to that. So I would recommend, before publishing anything, before putting your design on social media, to ask this question: should I publish, or should I first find out about this registered design right? And individual character, is the design different from existing ones? Does it give a different overall impression than the existing designs? This is very brief introduction to the requirements, and also to mention that by registering the design at the EU level, you get protection for 5 years, and then you need to remember to renew it, and the maximum protection is for 25 years, 5 years at a time. And here you can see some examples of what have been protected with the registered design right previously. And these pictures are from online design registers, and they have been registered at some point. Not all may not be registered at the moment. This slide is actually from our first webinar, where Katri Kiviniemi from Kastrén and Snellman showed this slide to give examples of registered designs, and Katri was very kind to let me use this slide also in this webinar, because I think it's a great overview of different kinds of products that you can register with this design right. There are shoes, interfaces, cars, jewelry, and today you will hear what will be possible to register in the future as well, for example, virtual designs. Using this QR code, you can find the first webinar of this webinar series and hear more about creating strong design protection by combining the different forms of protection, and more about registered design right. Then I want to just briefly mention that often when we talk about IP rights, we talk about protection, and that's of course very important, but it's also important to consider intellectual property as any property that you can sell or license. And licensing is a great way for your business to create more revenue, and by granting someone the right to use your trademark or design, for example, keeping the intellectual property right to yourself, but letting them use it and to pay you, for example, royalties in exchange, can be a very good business strategy. Also, you can use these for branding, marketing, and to attract investments. And here you can access the webinar on licensing that was part of this webinar series to find out more about how to make the licensing agreements and how to use licensing in your business. And then just briefly about how to take care of your IP rights and what to do after you have registered them. Monitor the market, know what is on the market so that you don't infringe others' intellectual property rights, but also so that you can react if someone infringes your rights. And also remember to renew your registrations. Make sure that you know how long they are in force and renew them on time. And on these questions, you can once again scan a QR code, and we will also send the links later to this webinar that was about design counterfeits, online infringement, and for example, if someone infringes your rights on their websites, how you can take down those websites and use domains, how to protect your domains, and also if someone infringes your trademark or domain, what you can do. Other tips, briefly, remember to make contracts in writing so you can show what was agreed upon. Also read contracts carefully, check what is said about your intellectual property rights so that you know what it means in practice. And also contact an IP expert for help if you're not sure. We are very happy to help you with these things. These links I will also put in the webinar chat. They are to the EUIPO website where you can find more information about design registration and also about the many services the EUIPO offers for small and medium-sized enterprises to protect their intellectual property rights. And last QR code in my presentation is to the survey we have published where we gather designers' views on the topic. No previous knowledge of intellectual property rights is needed to answer. There's also information on these things in the survey, but we would very much like to hear designers' point of view and how you see these IP rights, and you can leave comments in the survey. It's open until 17 November. Much on my part, and now I'm very happy to give the floor to Gailė.
Thank you, Rosa. I will share my screen with you. Can you see the screen share? Okay, great.
Yes.
So I'm glad to be here once again and to give you a short, very concise overview on design's legislative reform. I will try to avoid any kind of complex legal terminology and with the help of Paula, illustrate also with examples, practical examples, the changes that are that are upcoming with a new legislative package, and hope this will be useful for you. So it's an introduction only, and I will start with explaining why we needed this reform and what happened. So technologies evolve and they change the way we create designs, we create products, the way where we find products, what these new products are, how we use them. And obviously, design rights protecting these projects also change. The concepts change, and what can be done with it has to be changed. The limits also. So there are these global trends across the world that designs move to the virtual environment. It's undeniable. We can see these trends across the world, and also I show you here some trends from WIPO, World Intellectual Property Organizations. We can see that the filings for digital or non-physical designs, they increase, they skyrocket. So obviously, laws and practices had to react to these trends, and across the world, countries are revising. They are in different stages of processes, but the processes are happening. And these new designs, products, protectable by designs, they live in virtual environments. They can live in metaverse. As here, you can see Metaverse Fashion Week, where Adidas presented the clothing. And this is an example of a design which is not physical anymore, so it doesn't comply with the regular classical concept of a product, a physical product protected by a design right. It's non-physical anymore. Well, these designs, they can be found in various environments. In virtual reality, like in this example, they are found in augmented realities. They can be projected by a certain device, so they are not physical anymore, although a device is necessary to generate such a product. These designs, they interact, or products protectable by designs, perhaps they interact with users. You can see various applications that react to users' actions. This is something new. This was not present at the time when design laws, when initial design laws were created. So again, a legal context had to be adapted to this. These new designs, they move, they are animated, and this is also unavoidable. We want to protect also movement, animation, and transition. So the aims are to react to this, first of all, so to modernize the legal framework, but not only that. This modernization also is to ensure legal certainty. So we all must be sure what is to be protected, what is protectable. So what are designs, first of all, and what products could be protected by designs, and how. So we have, and what is the scope of such protection? If I protect it and it's in metaverse, how far my protection reaches? So these questions, they have to be solved. The processes to protect had to be simplified. We are all afraid of complex specifically legal actions, and this does not lead to smooth design protection and to the aims of protection itself, which should allow us to benefit from this monopoly that protection grants for the creators of these innovative or new products. So simplification is inevitable. We also had to make these designs more affordable, especially for SMEs, for individual designers. That was always the focus of the European Commission when creating the proposals and discussing those. And since the very beginning, SMEs, individual designers were the focus. Harmonization and alignment. If you want to register or protect your right, you want to be sure that after doing that in one country, member states, you are allowed to follow the same rules and register or extend the protection in the other member state, or the protection requirements are the same, and the way we understand what is protected is the same. So European harmonization is also one of the key aims or focuses of this reform. Alignment with trademarks regime is also important. We're used to procedures that are applicable to trademarks. However, some of these were not applicable to designs. And this created some legal uncertainty and some problems in practice. And all these aims, more or less, are reflected in users' views. The Commission, before defining the new laws or before drafting the proposals, asked users, so asked user associations, asked designers or individuals, asked also national offices that protect IP rights, what would help to use designs better. And users said that it's clarity, transparency of rules, simplification, awareness, also harmonization of procedures, and of course fees, which would be affordable. This would help to use design protection more on a broader scale. So this was also very representative. This slide is representative of what is aimed to reach with the reform. The scope, it's important to mention that, as you know, there are community-wide protected designs. So with EUIPO, you come and you file and you get protection for the entire European Union. So all member states are involved in this package of protection, but there is also still national protection. And this is safeguarded with the new law, so you can decide if you go first national, then expand to the other member states, or you go for some other, for community, for example. So all the laws are reformed. So the regulations that regulate the community-wide protection, but also Designs Directive that regulates the national protection. The timing, also very important before we go into details. What exactly are the changes, which is the most important part, is when will we feel the effect of these changes? So we're not 100% certain because the package was adopted, the basic law package was adopted, so directive and the basic regulation was already adopted, but we still it needs to be published, so we are waiting. We expect that it's the first half of November when we see the final texts of law. And then 4 months from the entry into force, it will start being applicable. So April, some provisions will be already applicable in April, and some other will be applicable in mid-2026. These are very specific provisions that will be applicable 2026. So the ones that needed some secondary legislations, acts to detail the effects of the basic law, to say it in simple words. And then Designs Directive, the act that regulates member states' laws, it has to be transposed to the member states' laws by the end of 2027. So this is more or less the timeline when we have to be ready for these new changes. So the core element of the reform is to change the definition. So what is a design? What is a product? And again, as mentioned, this is very closely tied to the realities, to the change in the technology environment and in the framework, and related to what really can be a design. So we have these new definitions, and they clearly say, I will illustrate it with examples, but I will say that animation is protected. It was never in the law before, and we didn't know. It clarifies that non-physical designs are protected. This, again, is a clarification because we were protecting non-physical designs, but it was never in the law, and there were some uncertainties to what extent we can protect those. For example, if light is protectable, or if there has to be a physical product still behind the design, behind this non-physical product that is applied for to be protected. So if both should be shown, or if only non-physical kind of projections is enough to be protectable. So now it becomes clear in the law that that not necessarily even have to have a physical product. Non-physical product is protected as such. So there is also a list of examples of what a product could be. So again, for the clarification, there are more examples introduced, such as, for example, graphical user interfaces or spaces, so interior, exterior environment. These are it is expressly stated in the law that these are protectable. Again, the visibility requirement is clarified. So when you protect, for example, light or lightning installations, you do not, you can do that because you show the design, the object of design protection in the application for registration. So the law clarifies that the features of a design do not necessarily have to be visible or remain visible at certain points of at certain times of use of such a product. Use requirement is not there in designs. In essence, you don't have to prove use. You don't have to really use a design to ascertain that it's protected. So as long as you show visibly in the application what you want protection for, and you comply with the requirements, it is protectable. So here you go, the examples. This is animation. You can protect animation. You can protect movement, transition. It is considered that animation sort of encompasses movement and transition as design features. The limits are there to be defined still. We immediately ask ourselves, or how long a video could be, or how many details it could show. Where are the limits of this? Can I protect the entire movie of 2 hours long, a 2 hours long movie? So this, we have to be reasonable and we have to think reasonably. Design still is an appearance of a product, so you can't really protect hour-long movies. But I will show you that certain elements we will still have to define in the future in the secondary legislation, or by discussing with the other member states, by cooperation and convergence programs, to see how we limit and how we somehow clarify the scope of such designs and the object of protection. But the idea that the law already allows us animation is a big move. This is, again, something that is non-physical and it's digital, and well, it moves. This, again, represents the example that the statement in law that states that, well, non-physical designs are protected. This is not only in non-physical design, it just disappears, as you can say, and then it appears once again. So it dies, as authors of this vase explained. It's an NFT artwork. They said it just represents the never-ending cycle of life. So it just dies, and it appears once again. So this could be protected according to the current definitions. The music is not protected. This is this is something out of protection. The projections. Here you can see a physical clock, but also a projection. So this could be protected with or without the clock. Or you can disclaim the clock if you don't want protection. Disclaimers are also, so usually these are dotted lines by which you indicate the elements of design that you don't want to protect. So we sort of disregard those. So these are in the law, and we know that we can use them. So if you want only to protect the projection, you can do so. So you can show the physical product and some additional elements that are not physical, or it can only be non-physical. It can be a projection, for example. It can also be light or lightning installation. there was a big discussion when the laws were drafted by some member states. Some member states really wanted to ascertain that light falls under the definitions and we can protect lighting installations. Therefore, perhaps digital designs as a term is not enough. We should speak about non-physical designs. Now we have in the law non-physical designs, so we can be sure that light can be protected. This is actually a protected design here at EUIPO as a pattern for surfaces, but you can see that this is not a pattern for surface, really. This is again an example of lighting installation. You can see that in reality, this light disappears, it changes. When the sun goes down, the design disappears, but you have it in the registration and the application for registration, and you have protection for it to the extent you reproduce it in the registration. So if in reality it is different, your protection, the object of protection, so what you have rights for, is exactly as you show it in the application for registration. The new law also introduces graphical user interfaces, and it's now clear that these fall under the scope of protection of design, of a design right. They can be animated, they can be static, as long as they can be clearly shown in the application for registration. Spaces or items arranged in a particular way are protectable, and the law clearly mentions interior and exterior environment. There were some doubts previously if these exteriors are protectable, but as long as you can clearly show in the application for registration what exactly you want protection for. So, for example, the background is neutral, and you show, visualize the design clearly, you can get protection for exterior environment as well. Previously, it was protected as a getup, but no one really knew what this getup was, and there was some misunderstanding because in the United States you have a different understanding of what a getup is, and in Europe we understood it some other way, so this getup disappears from the law, and we have now clearly the mentioning of these environments, exterior and interior. And obviously they can also be virtual, and there could be movement. This example perhaps is not the perfect example. There are many elements, but the idea is that you can present movement, you can present digital spaces, and this is all now covered by a definition of a product and a definition of a design. And yeah, so the law brings new opportunities, but there are still challenges. And the first and most important challenge that we have to address still in the future is how to properly represent these designs, because how to present them in the application. Because what we have now is the old regime. Very old-fashioned regime, and obviously this regime doesn't let these new definitions materialize somehow properly. So we can allow whatever we want, but if there's no way how to materialize that, then this law is not functioning. So currently we have 7 study views, and we can only submit drawings, photographs, computer-made representations. 3D representations are allowed, at least here at the office, but they do not form part of the scope of your protection. So you can present a 3D view, but it's going to be for explanatory purposes. It's not going to define really what you are protecting. So this is a big challenge for us, and I think I'm sure it's also a challenge for users of design system. And there are many practical situations when users are not able really to properly protect their designs because of these old outdated requirements, not only before EUIPO, but also before the national offices. So I stop sharing here because I know that Paula My co-presenter has excellent example from her practice and her experience where her clients had difficulties to really benefit from design protection just because of the old-fashioned design representation regime. Paula, I call you. I call you now. The floor is yours, and I stop sharing. Hopefully you can.
Thank you, Gailė.
Bye-bye.
So I'm going to share now my screen. Hopefully, tell if you can confirm now that you see my screen.
Yes.
Yes, great. Okay, so yeah, my part of the presentation is going to be based on a customer story, and actually my customer is today on the webinar. So thank you so much, Antti, for allowing me to share material on your design and also the story on how we protected your design and what thoughts came up in the process. So my client Gailė Sakalaitė, he is actually an individual designer, and he was studying at design school at the time when he created a mobile ornamentation. And he published his design on Instagram in 2023. And then he contacted an influencer to ask whether he wanted to also share his product. I'm going to now drag and drop the Instagram site so you can have an idea of what the product was about. So it's this wooden mobile ornamentation. And this became a huge success. In 1 week, it was like 1.6 or 7 million views. So suddenly, Antti started getting all of these messages and contacts from worldwide, from Europe and outside Europe about this product. And so he realized that, okay, now I need to do something about this. I need to protect it. He contacted Ornamo actually to get some help and some information on what steps to take in this situation. So the first thing was, of course, like to protect the design. That was very important, especially because it had become public in 2023. So he was in the 12-month grace period in which you have to protect it. Otherwise, after the 12 months, you will not be able to protect your design anymore. Antti wanted to file the application in the name of his company, but because it hadn't been established yet, so he had to file at the Finnish registry to register his company, Gailė Oy. Then he encountered some difficulties that there were 2 companies that had the word Gailė in their company name, so he had to negotiate with them whether he could register his company name for this type of products, this handicraft ornamentation or mobile. And because the other company's fields was so different, they said that no problem. So once he had the company registered, it was actually a few days before the grace period was ending. So it was like last minute marathon, but we managed to protect the design. So he contacted me to get my help on how to protect his design and where to do it. So I'm going to show you also another product of Gailė, so you will understand. Let's see. I'm going to drop it here. Yeah, there we go. So he has, let's go backwards. So he has 3 types of product, and all of them has a different amount of rings. So then when you move it, actually the shape changes. It really changes depending on whether there are 10 or 30 rings. So to show you, for example, this bigger one, to have also an idea on the product. So this is the product, and it was very tricky to protect because it depends on the speed. You know, it's impossible to get like twice exactly the same view. So yeah. So this was the product that we had in hand, and that we wanted to protect. So what did we do? We started with a design protection, knowing the limitations of the current regulation, the current practice in EUIPO. We wanted to first file in the EUIPO because he would get the 27 EU countries in the same application, in the same registration. And because it's very fast. So it was the fastest way to kind of like obtain protection in a few days. But because we had this view limitation, then we had to choose kind of the best views that would explain what the product was about and what kind of different versions the product could have when you moved it. So we decided to, together with Antti, we chose the 7 views that would become part of the scope of protection, of the protection itself. But we also added 3 more views as a reference views, just for reference purposes, just to kind of like understand better what the product was about. Here you can see the 1, 2, 3, 4, 5, 6, 7. So these 7 views were the ones that we protected, and these 3 were only as a reference view. We chose line drawings because line drawings give the broadest protection, as it doesn't claim the material and it doesn't claim color either. So, for example, now the product that he has is wooden, but in the future, he may do it in color, he may do in different materials, plastic, who knows. So by doing it in line drawings, we would kind of like get the broadest, the largest protection possible. And then in the description, we also explained a little bit about the views. So the examiner would understand that this is exactly the same product. There's not like different products, you know, because they do kind of like look as different products, but it's because of the movement. Nowadays, after April next year, well, not actually, no, it's going to be on the secondary legislation. So perhaps in 2026, 2027, when videos are accepted, then we would be able to file, for example, the video of the product that I showed you, and that would kind of give protection to the whole series of movements from the beginning until the end when the movement stops. But currently, we had to go with the seven still views. So these designs were first filed in the EU, and then during priority, which is 6 months after you have filed the application, you still have 6 months to kind of like continue in those countries that you want to protect. USA is quite flexible, so even though it had become public 12 months before, still they add the priority on top of those 12 months. So that allowed us to protect the design in the US as well. In China, unfortunately, there is this novelty requirement which is compulsory that the design has not become public before you protect it. So if you are interested in China, please do not make your design public before the first application has been filed, because otherwise, if you make it public, you will not be able to protect it in China. Then another thing that Ornamo and I recommended Gailė Oy was to file for a SME, like small and medium enterprise fund, which is offered by EUIPO. And with this fund, you can get the official fees back. It depends, it's up to 1,000 euros. It depends, of course, how many designs you have in the same application, but it's up to 1,000 that you will get the money back. I will talk about this fund later on in more detail. Yeah, and then one recommendation was also to protect the trademark. Because of the trademark, in the trademarks, there is like no novelty requirement. You can file for application for a trademark anytime. So that's why we started with a design, because we had this time constraint since it had become public already almost 1 year previously. So what Gailė would have done differently after having this experience of having a huge success on Instagram, and then being, in a rush to get protection. Well, the first thing is that he said it would be to save capital before registering the company, because even though when you register the company, you don't need like a huge amount of capital for the registration itself, but you need money in order to protect, to file design applications, to file trademark applications. And then also in this case, it's handicraft. He does everything by hand. So he needed material, he needed this infrastructure in order to be able to start producing the product and sell it to all of those customers that suddenly were contacting him on social media. And then also not to keep it secret until the design application was filed. That was also one lesson that he learned. So yeah, I think now, Gailė, you can continue. I will stop sharing now. There you go.
Okay. Thank you, Paula. That was a very nice practical example that illustrates actually where the problems are. And what I have to say now that is partially these problems are already solved, because in the Designs Directive we have clearly we have a clear statement: the static, dynamic, and animated form of visual production is protectable. And we can also see that drawings, photographs, and videos and computer imaging will be allowed. There will be possible to present one or more views. So there is no limitation of 7 views, at least in the Designs Directive. We will see if for the EUIPO or registered designs, EU designs, there will be such a limitation. It remains to be seen with the secondary legislation. What has to be still solved is the technical details. So we have to agree with the member states' national offices on the specific means, specific technical requirements, the technical standards on how to represent these designs. And for that, we have to cooperate to converge practices. Exactly that thing we were doing this morning. There was a long workshop with the member states' offices, and we were discussing the questionnaire that was distributed, how to best represent the needs of designers who create these designs and allow them to represent their creations in the best possible manner technically, so that we were sure where the limits of such a design is, where are they, and then also to allow to be future-proof for any kind of technologies that might emerge, and not to be too restrictive. So what we allow nowadays is JPEG. We allow these 3D standards like X3D, STL, etc. For trademarks, we allow video files, MP4. There is also this World Intellectual Property Organization. They have these additional standards. You can see on the bottom in red, we do not allow those for the moment. And we don't know if, with the aim of worldwide harmonization of standards, if we would need to allow those. So we discuss with the member states' offices. We will discuss definitely with the with the other stakeholders, user associations and designers. And I would take this opportunity to ask you here today, because you represent designers. You know what is best and what is needed. So if you could type in the chart, what in the chat, what would be your preferable standards, I would really appreciate that. And that's why I also want to talk about this. It seems like boring and perhaps very detailed subjects, but these really allow these modern designs materialize if we allow proper design representation regimes. For trademarks, we allow these kind of representations. For trademarks, we allow these kind of representations. So you can see dynamic view of a trademark, and we tend to understand that perhaps for designs, we would also think of something like this MP4 and also 3D, most popular, most used 3D representation regime. But again, this needs to be discussed. Also about the disclaimers. If you have a video file, a video, and you don't want to protect certain elements of a design, would you be able to really disclaim, use some dotted lines or shading in the video? So these specific details, they are there to be determined still. And this will be done via discussions. Also, simplification of rules. As I mentioned, it's one of the main aims of this reform. So designers could have it simple. Protection should be simple. So it was the possibility to abolish filings via national offices was abolished. So if we want to protect the design community-wide, we should go to EUIPO. Unregistered designs, there is such a possibility to protect unregistered designs, but nowadays, after the new law starts being applicable, it will only be EU-wide unregistered designs, so no national unregistered designs anymore. My colleagues are shouting. Just a second, I'll tell them to be more silent. Thank you very much. So no unregistered designs in the national level, and there was such a possibility to submit a specimen. So I don't know, a piece of clothing, for example, to show the design. It's abolished. So this is a simplification. Many simplifications relating to the filing date. It's very important when you protect to ascertain that you have a filing date, because that's when your protection really starts, and that's when you are the first one to first serve, first come. You know, the statement. So to have this filing date, you have to show clearly what you protect, what your protection is for. So what you want to protect. And there is this new notion of clarity. So it has to be clear what you ask, what the protection, what you ask for. a novelty that you have to pay immediately to a certain filing date. Some procedures are simplified and some new procedures are introduced. For example, if you have a problem with the views are not consistent to some extent, for example, or there is a certain detail that brings some unclarity to what you want to protect. It's immaterial, but still there. You're allowed to amend the application or alter the registered design already to avoid, in terms of alteration when the design is registered, to avoid invalidation. Deferment rules, Paula, I think, or Rosa already mentioned that there is such a possibility to defer the publication of your design. So you want to test your design on the market, you want to see how it goes. So you just register, but you don't publish. And the term is 30 months, up to 30 months. You can keep the representation secret, the view of your design, the appearance. So it's aligned across Europe now. It's 30 months everywhere. Importantly, as there is no publication of deferred design fee, so if you don't pay, as it was previously, don't pay, it's published now. If you have to pay it. Nowadays, if you don't have to pay this fee, but if you don't want that design to be published, you decided that you don't want protection, you have to surrender such a design. Renewal is also simplified now. The national offices will have the obligation to inform users that the renewal term is approaching, that you have to renew your design. Multiple applications. You might know that you can claim for a number of designs to protect a number of variants, for example, for designs in one application. So you pay the application fee and then you pay less for each and every additional design. That's a very good opportunity to save money because these additional designs cost cheaper. But this was limited previously because all these designs in the multiple application had to belong to this unity of to one class, to have this unity of class requirement, fulfill it. Now it's abolished. So as you see in these examples, in one application, you can fit designs belonging to various classes and you still get protection cheaper. However, there is a limit of 50 designs. So because obviously of the fee reduction, you have a limitation of designs. What's next? Also, in terms of simplification, we have this e-filing. Here I speak about the office only. Everything has to become electronic since 2026, mid-2026, when the secondary legislation is adopted. Now we are drafting our contribution to the secondary legislation, and we are trying to figure out the ways how and how to make it work, but it has to be electronic. So it's the sole means of communication with the office. All the notifications, also certificates, extracts from the register, everything, inspection of files, everything online through the user area. I think Paula will show us how that works, and that is already quite simple. Hopefully, it will be even simpler, and the office is obliged by this new law to help users use these online tools, so to provide any kind of support. That we can invalidate a design that infringes our rights or doesn't comply with the other requirements set in law. So it will be even simpler. So we call it fast track invalidation. If you see that your design is copied, you just file and we invalidate it very quickly. It comes also 2026, mid-2026. We're now discussing how it would be, what's the best solution, how to go about it. If it's all invalidities or some, what are the limits? But the idea is to allow users to defend their rights quickly, and also to eliminate designs that do not merit protection. For example, copy-paste designs. And this whole story started with some online platforms where rightful producers sold their products without design protection, and then some bad people would copy and run to the office, get protection in one day, and then inform these platforms to take down these products, although these were copied. So the rightful seller would then have to go to the office, apply for invalidation, because obviously this copy-paste design is not novel, it's a copy, etc. But it would take a year perhaps to invalidate in some cases, and would be more expensive. So there had to be ways to really get rid of such designs quickly and to stop the abuse of the system, because registration is very fast, it's very simple in a sense. There's no big examination, so we check if it's a design and if it's not contrary to the public policy and morality, and we register. And this might pose some risks, therefore some simplified invalidation procedure was necessary. Very quickly about the rights of design holder. So what can a design holder of a right do when the design is registered? So there is a list of possibilities. We have this monopoly that is granted by registration. I already saw a comment in the chart that someone has doubts about design protection. I can only promote it, because you get a monopoly, you get a registered right, and that registered right is a piece of paper, if you want, that you can go and show, and you have guarantees that there are no doubts that this is your right and that you were the first one, and it's not really difficult to prove it with a registration certificate, and the enforcement of your rights is way easier than if compared to copyrights, for example. So the law foresees a variety of options. What can you do as a design holder with your right? So you can use it in various ways. You can prevent the others from using. And the new law also adds one more right, exclusive right for the holder to prevent illegal 3D printing. So you are prevented from, you can prevent from creation, downloading, copying, and sharing and distributing copies in any medium or software that would allow a design, protect design as yours, be made. This is a novelty, and also it's an important novelty in some industries, like fashion industry, for example, and also in view of the artificial intelligence situation nowadays, it could be an important step. The holder of, this is also a novelty, the holder can prevent the transit of goods, of products through EU territory without even releasing it. So with the help of customs officers, you can prevent these goods which copy your design or are very similar to your design. There are some limitations, of course, to this right. So you can refer to registered design, for example, comparative advertising, or you can use it for the purpose of comment, critique, or parody. So as in this example, there is some sort of a parody, and design can be used for that. One more interesting change, which affects us all, as most of us, I believe, as car users, because we should be able to buy parts of our cars cheaper after this repair clause defense starts being applicable, because the parts of complex products that are aimed to restore the original appearance of this complex product, in order to restore its original appearance, they are not protectable by designs. So imagine you have a car and you have an accident, and the bumper of your car is damaged, and in the member states that previously had design protection for these parts of a car, you would have to buy the original part from an original car producer. You would have to pay more, logically. And with the repair clause introduction, you can buy this part from another manufacturer or seller. There are some requirements, there are some criteria, but the idea is that this spare parts market is liberalized, so monopoly does not apply anymore. A novelty also with the aim to somehow raise awareness and also to prevent infringement of rights is the D symbol or the registration symbol. The holders of design right can mark the products by this letter D to indicate that there is protection. They can also link we'll see how this will be implemented, but there should be a possibility to hyperlink to the entry in the register or to provide with a registration number. And the very last point on the fees regime, fees to be paid were also tailored, in essence, to simplify and to also to change it to some extent. So what the legislator wanted to guarantee is that we keep having EUIPO protection system, so community-wide protection system. We can't make it too cheap because then it comes too close to the national protection systems, and no one would apply for a design in Finland only, or whichever other member state, if more or less the same amount is to be paid for the community-wide protection. So after long discussions, which fees should go down, which fees should go up, the outcome is that the entrance fee, we call it, the application fee, remains the same. So it's not higher with the inflation, etc. It's not even higher. It's the same. However, the renewal fees become higher. And the rationale behind that is that also if a design is successful, after a number of years, it should pay its existence. And if not, there's no need to have monopolies in the register for a certain product that doesn't really, that's not worth design protection. So that was one of the rationales. But the fees are simplified. There are no brackets for these additional multiple application designs, and some fees are reduced, some new fees with the new possibilities introduced, some deleted. So the deletion is mainly because of the abolishment of paper. So whatever you can consult electronically, it makes no sense to ask for fees. So these are simplifications. That's more or less all I wanted to quickly go through about. And by saying that, it seems that it's already quite easy to apply for design protection, and I cannot promote it even more. And with this new reform, the new law, it might be even easier, or at least the aim is to make it even easier. I call once again Paula to show the practical example, how she advises her clients to apply and how that process looks like. I hope this will be useful also along the theoretical part. I stop sharing, Paula, okay?
Okay, so I'm gonna share my screen again. And so I'm gonna show you how to apply for design protection at EUIPO. There was a comment, a very good comment on copyright and design protection. Even though we're gonna go into questions later on, but I wanted to make clear that in this case, for example, in the customer or client story that I shared with you, that would have not been able to be protected with copyright. Copyright and design protection, they give different types. It's two different types of protection. So, for example, with copyright, which are like kind of I mean, it was creative, of course, the mobile that Gailė made. So it's not that it's not creative, but because it's a physical kind of like functional product per se. At least in Finland, it's very, very difficult to obtain copyright. And actually, there are many countries in which copyright cannot be protected, cannot be registered. That means that when you can't register that, you don't have the right, actually. So it's only in the moment of an infringement that you need to prove that you have the copyright protection. And at that time, you don't know whether you will going to obtain it. Usually the threshold of creativity is so high that most of the cases, they don't get any copyright protection. So this means that you wouldn't have any protection at all, and you wouldn't be able to defend yourself. So design protection gives you a right away, quite fast, and with that you can defend yourself. You can also license your right if you want to license that to another, for example, company that wants to produce your design and then get royalty. That's also one possibility. But with design protection, you have the registration certificate that you can use and you can enforce, you can defend. But with copyright, unless it's, for example, art or literature, music, films, this type of creations, they get copyright more easily. But the kind of like handicrafts, physical, they have to be really, really, really artistic, very creative compared to what has been done before. So it's really difficult to get copyright protection. So it's at least in Finland, and in many other countries, I know that it's the same. In others, you may be able to register with copyright, but it's not so straightforward that, you know, it's not necessary to protect because you will get copyright anyway. No, there are two different types of protection. So how to apply at EUIPO? I have included some links here where you will get all the basic information. In order to apply, you need to register. Okay, so you need to have an account. And there are two types of kind of like applications. The simple one, with which you can pay with credit card. And then there is this advanced form where you can pay, for example, with a bank transfer. And then it's also used for more complex cases, okay? Because I am attorney and we have an account of my company, we need to use the advanced form, but it's not so different from the form that you would use. So I'm gonna show you how it works quickly. So then we have also time for the funds and then questions. So when you are here on the basic site of EUIPO, here it says apply for IP, and then you go for apply for designs. And here there are videos, information on how to apply. There's the start application. And I'm gonna use the Gailė examples since we have already used them in this presentation. So here it's file a new design. So you can write a personal reference. Here there is a chat. If you need any help from EUIPO, you can also chat. Then you need to choose the two languages. So the first language, it's any kind of official language. And the second language, there are only these four, and English is the fifth one, but because we choose it as the first language, I'm just gonna, since I'm Spanish, I'm gonna choose the Spanish. Then you just click here, add design. So it's gonna open up the different kind of like steps that you need to take. Here is drag and drop. So I could drag the 7 views, but just for an example, I'm just gonna drag one. Okay, so there we are. If I had dragged and dropped 7, then you would see the 7 views there. Then you need to decide whether you want to defer the publication or not. So if your design is still secret, you haven't made it public yet, and you want to launch it, let's say, in half a year time, then I would suggest that you defer the publication, and then when the launching comes close, then you make it public. I'm gonna click here, for example, no. We don't want to defer. In this case, it was already public. Okay, and then the product indications. This is easy. Like, for example, if I write ornamentation, for example, it gives you all the terms that include this ornament. I'm going to click this one and then add. And so because I have used the terminology that EUIPO accepts, this is a fast-track compatible application. Fast-track means that in one day, you will already receive the confirmation from EUIPO that the application has been accepted. So it's very, very fast. Within 1 week, you will have the registration certificate and you will be able to defend yourself already from that date. Here, designer details, you can add designer details if you want or not. It's not compulsory at EUIPO. In other jurisdictions, for example, the US, you need to say the designer details. So if you're going to apply, for example, in the US afterwards, I would enter the design details in this application. The description, I showed you already the description that I had written for that application. This is only for references. So the examiner kind of like understands what the product is about. Or if there are disclaimers, that means that you want to leave certain elements out of the protection, then you can also write here that I'm using this disclaimer to kind of like leave out this and this and these details from the, but this is just for explanatory reasons. Claim, this is if you had filed, for example, first in another country, and then you want to claim priority from that application, then you would claim the priority. In this case, we're not going to claim priority. Here, it's also, there are certain exhibitions that are accepted as a priority claim. So if you had made your design public in a well-known exhibition, you can also enter the exhibition information here, like the date, the name, and the place. And this WIPO DAOs, well, it gives you a code. Okay, it's just 4 numbers. So when you apply, for example, in the US and you want to claim priority from this application, it's only necessary to inform the US Patent Office of these 4 numbers of this code that you obtain with this application. But you don't need to, this is quite simple. You don't have to worry about this WIPO DAS code at this moment. So then you just add design, and there it is. Then it opens up the next step, which is the name of the applicant. So in this case, I would write Gailė OU, and there it is. So I would click there and I would say import. And it will give me the details of the company because it had been already entered in the system. If you cannot find or you want to file for your own company and it's the first time that you do it, or your name as an individual designer, then you can always create a new applicant, and then it's quite easy to enter the information. So the name, the nationality, address, etc. And then here is the representative. It comes automatically, Berggren, because I have logged in with our account. But if you don't have a representative, then you just leave it blank. And here You understand and accept the terms, and then the signature, and then you would go to payment. So it's as simple as this. Once again, I want to stress that filing the application itself is not complicated. But what it is very important is to make a very thorough protection strategy before filing the application, because the protection is based only on the pictures, on the drawings, on the views that you file, and that's it, not on the product itself. So when there is an infringement, a copying, for example, that someone copies your product, what is going to be shown is, or compared, is the copying product with the registration certificate that you have and the views that are in the registration certificate. So this is why it's very important to see whether, and to think whether you want to file the whole product, whether you want to file the product in black and white, in color, whether you want to certain details of the product protect separately as their own designs, etc. So there are like many questions to think about before preparing the drawings and doing the application. So these two formats, but they both have this fast track. So the application becomes accepted in a really fast way. And then also the deferment of publication to make it secret, keep it secret to up to 30 months if you want to. And then, well, Gailė has already informed about the fee structure. So it will become much simpler and straightforward. And it's going to be cheaper. So for the first design, it's only €350. The additional design in the same application is just 125 official fees. There will be no publication fees anymore. And the deferment, so if you want to keep it secret, there is a slight additional fee that you need to pay. It's 40 for the first design and €20 for the additional design. Okay. So support mechanisms. This is very important. The SME fund that EUIPO offers. It's very important. We also learned that with Antti, that it's important to file first for the fund. When you get the voucher from EUIPO, say like, yes, you can use the €1,000 for a trademark or a design, then you file the application and you pay the official fees. Once you have paid the official fees, you claim the money and EUIPO will refund the money that you have paid for the official fees. There are also two other types of funds. One of them is for patents and another one is for IP scan. This IP scan is very good. It's made by a professional and it's about an hour and a half interview with you about your business. And it's also about the planification of your business, and they check what needs will you have and what steps to take. So if we had time to do the IP scan with Antti, we would have checked, okay, what is the situation now? What kind of protections do you need? In what time frame? Etc. And what is the budget? So this is very good. The value of IP scan is €1,500. And I was at EUIPO 2 weeks ago, and we were informed that most probably this will continue. This SME fund will continue next year too. So they will be available for you to use and to apply. Okay, so this is me. Any questions? Or maybe Gailė, do you still have something else to present, or is your presentation ready?
I still have a slide
Yes.
on the future challenges. It's
Definitely.
just one slide. I hope you have patience for that, and then we go to the questions, okay? I'll just quickly share that one. Just wanted to give a very high-level overview of what's awaiting. So the secondary legislation, the laws that provide more details or help to implement the basic set of rules that we discussed in the drafting, in the making currently. So they will have to be adopted, and we expect them to be applicable mid-2026. EU harmonization of rules. Here I would mention the transposition of the Designs Directive. So whatever the Designs Directive say has to be transposed to the national laws of the member states. That's very important. And among those the rules would be the representation regime. What we really, really hope for and strive for is the harmonization of these basic rules, how we represent design. We now have it harmonized, what a design can be, what a product can be, but we want to have the way to materialize that also aligned across Europe. So wherever you go, whatever is the scope of your right, it is obtained in a more or less the same way, and it is the same, more or less, it's interpreted in the same way. So that's why we started discussions already with the member states' offices on the possible regime, representation regime, and these discussions will continue and hopefully will involve more and more stakeholders. So we have the framework completely aligned to the extent possible, basically, I would say, across the European Union. International harmonization of rules is equally important. We participate in various forums with World Intellectual Property Organization, but also with some other national offices and user associations, and we discuss emerging issues. Design Law Treaty is one of the instruments. It will have to be signed, or is planned to be signed this month. In Riyadh, there is a diplomatic conference, and the Design Law Treaty will set the minimum basic standards for design protection, and these will have to be applicable across the signatories, the countries that signed. It's a very important instrument, and discussions have been ongoing for quite some time, and now it's the time to somehow put that in paper and agree on that. Awareness has been, design awareness was mentioned many times, and this event is also part of the awareness raising. We all want you to understand that design protection is beneficial. However, it has to be tailored properly, as Paula mentioned several times in her presentation, that all these strategies are different and it has to be assessed case by case basis. You can't apply the same scenarios for different designs and different designers and products. So, however, we want to be aware of what is possible, and we want also to receive feedback from you. So the moment something is not clear, it's already alerting that something has not been explained properly. Artificial intelligence is something I had to mention. It's also a challenge for all of us on various layers, not necessarily designs only. We are thinking about it here at EUIPO. We are discussing with the other offices and other stakeholders how to go about it, because it's inevitable that designs will be created by AI, and obviously there are already questions what to do with such designs. Can they be protectable? Can AI be a designer, a holder to what extent we are supposed to know about the AI involvement, and to what extent AI involvement is still okay for design protection, or maybe there is no problem at all because designs are not copyrights and there is no, not that human touch is not that essential. So all these are questions, and very interesting questions, I would say, and we are looking at it, and that's the future. So that was all I wanted to say about the future steps, and I believe we still have some time for questions and answers, right?
Yes, we do. Thank you both so much for your really amazing presentations with a lot of practical examples to show what this topic is really about. And also I want to thank Koye and Antti for sharing their story. It was great to hear an example about how to use IP protection in your business. And yes, now we have time for questions. There has been some questions in the chat, and also if someone has questions, they can just put on their camera and microphone to ask. Maybe I could first take the questions from the chat, and there was the copyright question that Paula already addressed, and there was a clarification to the question. So maybe I can ask you, Paula, about this. The question on the chat is, if it was an answer to my question earlier, it doesn't answer my question. Also, what do you mean it is hard to protect copyright? Isn't it automatically yours once you create anything? Is that so then that if you do not register your design and then sometime later someone can register or file patent for the same or similar thing that you created earlier?
Okay, we'll try to explain. And if my explanation is not clear enough, then please, Rosa, you can also add your input as a lawyer. First of all, for patenting, because many times the words get confused, patents are for functional protection. So it's how something works. It's not visible. So as you said, the lamp, you know, how it works, what's the circuit inside the lamp, etc. That's for patenting, it needs to be secret, okay? So once the product has become public, you will not be able to patent anything, okay? So as long as the invention has become public, that is not patentable. So if you don't protect your patent, no one else will be able to register it if your invention has become public. So there is this novelty requirement that is compulsory in order to be able to file a patent for an invention. Regarding designs, as I said, in China, for example, this novelty requirement is also compulsory. So as soon as you make public your design, you will not be able to protect your design, and no one else will be able to protect that design either for themselves, okay? They will be able to copy because you will not be able to defend yourself since you haven't registered your design. Regarding the differences between copyright and design protection, copyright is not harmonized. So in some countries, you can file for an application to register your copyright. For example, in the US, in Finland, that is not possible. So that means that you would automatically obtain copyright by creating something. But what is the problem here? The problem is that the threshold of creativity is very high. So because you don't have any certificate, you don't have any document to prove that you have that right, once you have an infringement, then you would have to first obtain some kind of proof that your creation benefits from copyright. And in most of the cases, even though designers feel that they should have copyright, that their creation is creative enough in order to obtain copyright, in most of the cases, they will not have copyright and they will not be able to defend their design. If in those countries in which you can register your copyright, then it's different, because then you obtain kind of the certificate, copyright certificate, with which you can prove that you have that copyright. But whether your creation is going to be artistically enough, high enough in order to obtain the copyright or not, that remains to be seen. Whereas with design protection, you would get the registration certificate as soon as you file for EUIPO, and you would have the paper. And with that, you can defend yourself, you can license your right, and you can also avoid, or you cannot, or like you don't allow others to use your design or copy your design. So you can kind of like defend yourself. But with copyright, it's not so clear. Only on those examples that I said, like music, literature, etc., in those cases, copyright is created automatically. But in this kind of like physical, artistic products, it's not so clear whether you will get copyright. Most of the cases, you will not obtain copyright. So I don't know whether it's still unclear. Do you want Rosa to add anything to what I said? Perhaps.
I think your answer covered it. I think it covered it very well. First, you said that patents are for technical solutions. So, and when we think about copyright and design, from my presentation, it's important to remember that they do not rule each other out. Even if you have copyright, you get stronger protection when you also register the design. You can have the both at the same time. And when you register the design for the product, you don't have to be concerned if the copyright will protect that product. Then you have the design registration that you can rely on if someone infringes your rights. And also in online environments, when you can show that you have the registered right, it's often a lot faster and easier to get the infringers to stop what they're doing than sending them a message only relying on copyright. That's of course possible, but you get strongest protection by combining these. But yes, I think Paula answered this very well. We have also other questions. I'm going to look from my colleague's computer because my internet connection threw me out from Zoom at some point. There was a question, and I could ask this from Gailė. Would you like to hear views on protecting web or app interfaces via design registration? This was already covered in the presentations, but do you have something to add to that? And I think we have another question from the same person, so I'm just reading if it's also relating to this.
While you're reading, I will just quickly answer.
Yeah, of course, yes.
You can protect these interfaces, and the way you protect depends on when you protect it. If you protect it now, the old rules apply. You just submit 7 static views, and you protect that the way you want, and in the future you might have more possibilities, more views, a video, etc., etc. But of course, it is within the. It is a visual appearance of a product. Let's say it's design protectable subject matter.
Thank you. There was the same person asked then that. I have a question about extending protection outside EU, say US. Is there any preferred format, e.g. black and white line drawings in representations, if we see that eventually filing will also be done in US? And if either of you wants to answer this one, Maybe Gailė, you
Yeah.
can continue, or
I
Paula?
can answer. Yes. So in the US, both line drawings and renderings, like 3D pictures, are accepted, and photographs too. From my experience, line drawings are accepted much easier than the other two formats, although they are also accepted. So what is very important in the US is that the depth of the product, if it has like the shape, the roundness, for example, and the depth, if there are like holes, how deep the holes are, etc., that this is clearly shown, because otherwise the examiner in the US is going to give an office action and is going to ask to amend the drawings. I also want you to understand that the US system is completely different from the EU system. So the US system is a patent application, and it is going to last and is going to be examined as if it was a patent. So in most cases, you may have some office actions regarding, so this office actions means that you need to make some amendments, some changes to the application and to the views, if the examiner feels that they are not clear enough. But for your question, I would go for line drawings if you are probably protecting also in the US.
Thank you, Paula. Another question in the chat about the grace period, from which point it starts: online publication, exhibition, competition, submission, email, presentation. Is there no way to protect your work or design after one's grace period expires? E.g., in case there was an exhibition in a well-known museum, isn't that a proof of creation time, and which work was original?
So the grace period starts from the publication date. As soon as you make it public, it doesn't matter whether it's in a museum, where it's in an exhibition, whether it's on social media, on your website, it doesn't matter. So the moment when the publication has been made, it has been known to the public. For example, a shoe, whenever you test it on the park of your city, that would be also that would make it public, because anyone can see that, and recognize, this is this brand's shoe, and take a picture and then share it. Like Rihanna, for example, when she, everything that happened, that she had put the shoes on before they had been protected. And what happened? They filed the application 12 months later after she had put the shoes on, and the registration was cancelled because they could prove that she had made it public more than 12 months before the application was filed. So the only thing that doesn't really make something public, it's it's an NDA agreement, a non-disclosure agreement between two parties. So let's say that Antti Koje had this mobile ornamentation, and he wanted to have feedback, and he showed it to a specific group of people with an agreement saying that this is a non-disclosure agreement, so the information and what happens in that meeting stays secret. Then that wouldn't be seen as becoming public, because there's this secrecy agreement between the parties that are, seeing the design. But otherwise, as soon as you make it public, then the 12-month grace period starts to count. And then China drops off from the possibility of protecting your design, because it hasn't been filed, the application hasn't been filed before the product or the design became public. So is this clear enough?
I think there's another part of the question
Yes.
where it asks if there is no way to protect the work after once the grace period expires. And although exhibition could be a proof of creation time and that the work was original.
Yeah,
So,
no, but
yeah.
up to 12 months, unfortunately, you can no longer protect your design.
Yeah, it's a registration system. You first come, first served, and then you can, in theory, you could register, but there could be someone coming and say and invalidating your design as not being novel because it was already published after the grace period and made available to the public. And originality is not a criteria, and you don't have to really prove originality for designs. It's a copyright criteria. So for copyrights, this kind of work could perhaps, if it complies with copyright requirements and criteria, perhaps it could still be possible to protect it as a copyright, but with all the downfalls that Paula explained previously. And yeah, because there is this accumulation of rights, so you can have copyright and you can have design simultaneously, or these rights in some ways overlap to some extent, could overlap, but it's difficult really to obtain copyright protection and to prove it and to fight infringement. So I fully agree with what Paula explained previously about the risks of relying on copyright only. So the smartest way is always to protect your creation from all possible angles and to avoid losing it. And you have the monopoly for registering. When you register a design or a patent, you have the monopoly, but there are certain requirements. And for patents, these are very, very strict. These have to be novel. For designs, you get registration faster. But of course, it's then vulnerable if it's not novel, that design, and it goes out of the grace period. It can be declared invalid later. So that's the addition to what Paula explained.
Yes, thank you both very much for your answers. I think these answers covered very well the questions we had in the chat, and we have time for one more question. I don't see questions in the chat, so maybe someone wants to ask directly or in the chat before we conclude. No questions apparently. Before we end the webinar, I wanted to mention that after the webinar, you will get an email with a feedback form, and we would very much appreciate if you would fill in the form, giving us feedback for the webinar. It helps us to organize similar events in the future. And also, if you want to answer and give your views to Gailė's question about how US designers view this and answer her, you can use the feedback form, or if your answer is longer, you can send directly to me via email. I can then forward it to Gailė, for example. But other than that, thank you very much for Gailė and Paula for your amazing presentations. Thank you, Koyeo and Antti, for the story, and I also want to thank Dita for her presentation about BEDA, and of course I want to thank our audience as well for joining us for the webinar, and thank you everyone, and have a nice evening. Bye.
Good evening.
Thank you.
Thank you.
Thank you.
Bye.
Bye-bye.